Welcome, everyone. Welcome, mamas and grandmoms, to our Cottage Meeting Moms for America, Healing of America seminar. Today is I'm so glad to have all of you with us from around the country. I know I'm in Chevy Chase, Maryland, just about a 15-minute stone throw from the White House. Vivian, our executive assistant for Moms for America, is in Texas. Congratulations. I heard your governor just lifted the mask ban and opened up businesses.
Hallelujah, Governor Abbott, because I haven't been happy with him for a while. So yes, 100% open and no masks.
No mask.
But we still have our local municipalities. So if anybody's in Texas here, ladies, call your local people and ask them to follow the governor's lead. So there's my PSA.
I believe Mississippi also put forth some kind of mandate like that as well. I wonder if Florida, does anyone from Florida, does Florida have a mask mandate or all businesses open? Seems like those are my three favorite states right now. I'm sure North Dakota and South Dakota is probably pretty good too. But anyways, well, good things are going on. I'm hoping there's a thaw from the cold, dark winter that was predicted by President Biden. Hopefully things are brightening up again, lightening up a little bit. Let's hope. Since COVID last summer, we started teaching classes online for Moms for America. And last summer, this is the Cottage Meeting Resource Guide, and we sell it in the Moms for America store. And it has 12 introductory lessons. This is probably one of the best resources with videos and quotes and stories that I've taught my children for years. I pulled this book on my lap during morning devotional and then would teach from it. But it has 12 lessons, and I taught all these lessons online last summer. And it was a group of about 3 to 5 women, and we kind of mirrored what a cottage meeting would look like in the home. And so we teach and questions, and it was very interactive and participatory. We don't comment as much on this cottage meeting just because there's so many of us and so much material to get through. But if any of you are thinking about starting a cottage meeting, this would be a great resource to start with because it has all 12 lessons and it just shows you how to lead the discussion. You can go online and watch some of the classes. You would find them under Virtual Cottage Meeting Moms for America YouTube, and up would come the 12 lessons. So this is something you might want to think about in the future, or just get this as a great resource guide. I've taught the community in my church, my children, and publicly taught using materials from this book. It's a great resource. So we're currently teaching an online class, Healing of America. It's 4 books. We're on the 2nd book, The Charter of Freedom. I hope that you're getting these books and you're keeping up. We do a section a week. There's 4 sections in each book, and the key is in the back, and you fill in the blanks kind of thing. And we're talking about the Constitution. This can be kind of a daunting thing, studying the Constitution. But I hope as we're breaking it down, it's starting to make a little bit of sense to you. 2 weeks ago, we talked about, remember the 7 articles. Does that look right to you? The 7 articles. If you can remember this acronym, LEGSASAR, you can remember the 7 articles in the Constitution. So 2 weeks ago, we talked about the legislative branch. And last week, we talked about the executive and the judicial branch. And we're going to talk about the 4 other articles today. The states, Article 4, Article 5, amendments, Article 6, the Supremacy Clause, Article 7, ratification. Now, we have that 1-page Constitution outline, and it's on our Moms for America website under Healing of America. You click View Presentation, and it will be there. You can see where you can click and download that 1 page of the outline of the Constitution, which is such a good go-to resource that I've used to kind of jog my memory about what these 27 amendments are about. So we're going to also talk about the first 10 amendments in the Constitution today that are known as the Bill of Rights. And that is what our founding fathers gave us, these 7 amendments and these 10 Bill of Rights. And they actually gave us Amendment 11 and 12 too. So if that's a quick trick question. If anyone ever asks you how many amendments did our founding fathers give us? It's 12, not 10, but 12. And so anyways, that is what we'll talk about today. So I hope, did any of you get a chance to watch that 13-minute video entitled The Most Powerful Political Office in the World? If you didn't, I would recommend, because I think it helps you to begin to understand how the executive branch has gotten so much bigger and so many more responsibilities than what our founding fathers intended, and how one man or one woman can't possibly do everything we're asking them to do, or why they are as powerful as they are. They should, that office of the presidency should not be as powerful as it is. So I'd really highly recommend, and I think that was on the recommended Julene's picks, that the email that you should have received yesterday. Also, the judiciary, remember we talked about the judiciary branch, the third branch of government, and someone brought to my attention there was an excellent documentary about Clarence Thomas. He is one of the 9 justices. Remember, those justices on the Supreme Court serve for life. And he is the longest sitting Black justice on the bench in the history of the court. But interesting enough, Amazon Prime removed that documentary last month. For Black History Month, Amazon Prime was highlighting a lot of, interesting Black films and documentaries, and they had one on Thurgood Marshall and a couple on Anita Hill, and they had Black love, Black joy, Black history makers. But wouldn't you know, for Black History Month in February, they removed Clarence Thomas's documentary that came out in 2019 called Created Equal, Thomas Clarence, in my own words. And I was reading about the documentary, and when it was premiered a year and a half ago, it was said that there was not a dry eye in the theater. It was really a beautiful, powerful documentary on our current Clarence Thomas. So Amazon Prime, for no reason, just removed that last month, and it cannot be found. So it is my goal this week, to find that documentary and watch that on Clarence Thomas. So anyways, okay, we're going to get started now studying our last four articles. There's 7 articles in the Constitution. We're going to study the last 4 and then the 10 amendments today. So let's turn to the very first page of Section 3, Seminar 2, Section 3. So prior to the Constitution, the states were not treating each other very kindly. In fact, some of them were treating each other like they were the enemies. When the country was first, formed in 1776, those Articles of Confederation didn't bind the country together. And so in the Constitution, our founders wanted this Article 5 to talk about, how we can improve the relationship between the states. And so there's 4 sections in this 4th article that relates to states' rights. And in the very first section, ladies, it talks about the official acts of each state must receive full faith and credit by all the other states. Now, what does this mean? This is a very important clause because of what has come from this clause, especially in the last decade or 2. So what that means is, in Section 2, that the citizens of each state shall be entitled to all the privileges and immunities of the citizens in other states. So that means that there's just natural rights of citizens that we have to be able to travel freely from state to state and set up businesses in other states, and to be able to sue or to have protection of our property in various states. But it doesn't include acquired rights. So there's natural rights of citizens, and then there's these acquired rights of citizens in each of the states. That means that if you belong to a certain state, you have certain advantages because you pay taxes for certain things like college. You get an in-state college reduction to go to college, versus if you come from out of state, you have to pay more money because you haven't been paying into the taxes to maintain these colleges, and like hunting and fishing licenses and so forth. You have to pay a little bit more if you're coming from out of state. So these acquired rights Also apply to like driver's licenses, marriage licenses, concealed weapon permits, and so forth, that other states would need to be able to say, okay, yes, I recognize your driver's license in my state. But, okay, now are you listening, girls? This is the big but. But acquired rights do not include actions that certain states can legislate that are illegal or inappropriate in their state, such as gambling, same-sex marriage, plural marriage, prostitution, child pornography. So gay marriage was not considered a natural right. It was considered an acquired right. So states, if they wanted to, it was up to the individual state up until 2013 to determine if they were going to recognize gay marriage or not. No states had ever recognized gay marriage until 2004, okay? And before 2004, there was beginning to be some rumblings about, accepting gay marriage. And so in 1996, Congress passed, have you heard of it? DOMA, I think it's Domestic Marriage Amendment. No, it's not an amendment, domestic. And anyways, it was called the DOMA law. And what it meant is each state was able to determine that marriage is between a man and a woman, okay? But what that did is when they codified in 1996, they took like an inalienable right, marriage is between a man and a woman, and they codified it into law. Guess what it was going to do? It was going to open the doors for the Supreme Court now to be able to interpret that law because you codified an inalienable right. That's why it's probably best not to codify God-given rights. We don't need the legislative branch to say that there are rights because they come from God. They don't come from government. And that's exactly what happened in 2004. Massachusetts was the first state, their Supreme Court, to pass gay marriage. And over the course of 2004 to when this case was taken up in the United States Supreme Court 9 years later, 37 states over that 9 years started to pass these gay marriage laws. And so a person that is recognized gay marriage in Massachusetts maybe might move to a state that has not legalized gay marriage. And then that was where the friction, this is where the problem was. So the Supreme Court took up this case in 2013, and they declared that gay marriage was now going to be the national law of the land. Now, the dissenting opinion in that Supreme Court decision in 2013 said that same-sex marriage was not endorsed by the Constitution, so the Supreme Court should not rule on something that the Constitution is silent on. And that's exactly what the founders intended, that if the Constitution didn't specifically address certain rights, those rights were to go back to the states and the people in those states to determine for themselves. It was not to be a federal issue if the Constitution was silent on issues. And this is what the originalist judges believe. Now, the activist judges believe, we talked about this last week, that the Constitution is a loosely constructed, broadly interpreted, it's a living document, and so interpretations can evolve over time. As we study the founders and what they intended, that is absolutely opposite and contrary to what the founding fathers felt. That, remember, Jefferson said, we want to bind the federal government down with the chains of the Constitution. We want to prohibit their rights. We're only going to tell them they have to stay within the limitations of what the Constitution says. And if it's not addressed in the Constitution, then it's to be delegated back to the states and the people in the states to determine for themselves within the states how things are to be written. So that check and balance began to get off when the Supreme Court in 2013 got involved with legalizing gay marriage, and what has come from it now, and we'll talk about it in a minute, is a whole host of problems, including the Equality Act that was passed in the House last week. And we will talk about that Equality Act in just a minute. Okay, so moving on in section 3 of Article 4. So we talked about section 1, 2, and 3. Just talks about, we talked about this last week, how all states should come into the union on equal footing, but that didn't really happen because as the Western states and Alaska started coming into the union, the government held vast parts of their lands. And so constitutionally, these Western states where the government holds, 50, 60% of their lands, 40% of their lands, they're always trying to argue to get some of those lands back. Okay, let's go to Article 5. How do we amend? Before we do that, the last section of Article 4 talks about the United States shall guarantee a Republican or representative form of government for each state. Girls, I just want to remind you that the founders were very intent. This was a republic. There was representative government. This was not a democracy. And representative government is based on the rule of law. And the rule of law is God's law, nature's law. The most reliable basis for sound government is natural law, God's law. This is what our founders intended. A democracy is the majority rules, and that the law is based on feelings or emotions. And when the majority rules, we don't get good law because it all depends upon the winds of the time and the trends of the day. But the rule of law rooted in God's law, our inalienable rights, keep us kind of grounded and keeps you in that people's law in that center from swinging on that pendulum too much into anarchy, no government, or tyranny, too much government. So when we look to God to define our laws, we stay rooted because those laws never change. So like murder will always be punishable according to God's law. But if you let the majority rule, if the majority of people think certain forms of murder is okay, then they begin to change the laws. And we're kind of seeing that instead of saying rooted in the principle of law, we're now kind of, we're kind of taking a pulse of our feelings and our emotions, and that's dictating the law. So I love this book here, The 5,000-Year Leap, because it talks about these 28 principles that our founding fathers used to write the Constitution. And it says, principle number 23, that a free people must be ruled by law, not by the whims of men, not kind of by charismatic leaders or what's popular right now, but the rule of law. And the rule of law is based on God's law. And we're going to talk about how our founders felt that, why that was the case in just a minute here. Okay, so Article 5, we're on Article 5 now. How do we make changes to the Constitution? They knew that our founders knew that in the Articles of Confederation, it had to be unanimous in order to make any changes, and they realized that was stalling out progress. So they said, we will show you how you can make amendments. If 2/3 of the House and the Senate, if we decide on an amendment, then it has to go to 3/4 of the state legislatures. And if that passes, you have a new amendment to the Constitution. Keep in mind, every amendment that you pass supersedes something that the founders gave us. So amendments can be fraught with peril. And we're going to talk about the amendments that we've received since the founders gave us what they gave us and how it's disrupted the balance of power. And we'll talk about that a little bit more next week when we talk about those that came after what our founding fathers. But they intended, if needs be, to amend the Constitution. But it's difficult to amend it. In fact, the last time we amended the Constitution was 30 years ago. And really, it was 50 years ago. Amendment 26 when they moved the voting age from 21 down to 18. And then the last amendment, which was 30 years ago, was really an amendment that James Madison 230 years ago proposed, and Congress just didn't ratify it until 30 years ago. And it simply stated that Congress could not receive a pay raise while in session, while in that term. So each session in Congress lasts for 2 years. So they couldn't vote themselves into pay raise while they were in office. So we really haven't truly had an amendment in 50 years. There's a second way you can amend the Constitution, and that's called a constitutional convention. And what that means is 2/3 of the states get together and they petition the government to have a constitutional convention, kind of like what they had in 1787 in Philadelphia. And they file this application stating their intentions for the amendment. And then when they come to an agreement, 2/3 of the delegates that are sent to by 2/3 of the states, and then the amendment they come up with has to go and be approved by 3/4 of the state legislatures. Now, this way to amend the Constitution has never happened. And really, it's a way, first of all, for the people to kind of go around Washington, D.C. If Congress is not cooperating, the people can just kind of rise up, the states can rise up. So Congress has been anxious not to let this happen because it decreases their power. So whenever 2/3 of the states have petitioned for a convention or gotten close to it, Congress usually capitulates and has passed that amendment. And the 17th Amendment is an example of that. And we will talk about that next week. So that's how we make changes to the Constitution. It's difficult, and it's difficult for a reason. Okay, Article 6, are you following me in your little book? You're moving right along. Article 6 is the Supremacy Clause. This is such an interesting clause, ladies, because it tells us it's only 3 sentences. Now, I hope you got your little handy dandy pocket Constitution and you're reading it now that you kind of understand how the Constitution is organized. It's not such a mystery. But this Article 6 talks about what is the supreme law of the land. And first of all, the first section says, hey, we're going to honor all of our debt from the time we become a country in 1776 and the debt we accrued in the Revolutionary War, which is an honorable, beautiful thing. And then section 2 is where it gets really juicy. It says there are 3 areas of federal law which are like the supreme law of the land. That is the Constitution, laws established by the federal government, and treaties entered into by the United States. And remember, when the president makes a treaty with another country, 2/3 of the Senate has to approve that treaty. So the number 2 is the thing that would be in question today. Okay, well, what is considered a law established by the federal government? Okay, so we know the legislative branch is what makes laws. So there's no reference here to executive agreements that a president might make with a foreign country, or even an executive order that has become very popular amongst presidents to make law in the last really century. And especially in the last couple decades, we see presidents legislating, making law through executive order. And that is not the supreme law of the land. And look, there's no reference to edicts by regulatory agencies. Regulatory agencies, remember, fall under the executive branch, okay? And they're just supposed to be creative in order to keep law within the executive branch. So like OSHA or some of those regulatory agencies, that's not the supreme law of the land. And look here, even the edicts by the Supreme Court, which constitute judicial legislation, are not considered the supreme law of the land. So when gay marriage was legalized by the Supreme Court in 2013, if we would have had just a couple governors say, look, that's not the supreme law of the land, I'm not going to adhere to this Supreme Court decision. If you would have just had a couple governors rise up and use this supremacy clause as the supreme law of the land, I think we could have seen maybe a different outcome from that Supreme Court decision. And so the interesting thing is laws established by the federal government made in pursuant of the provisions set forth in the Constitution. So what that means is the laws that Congress can make have to be pursuant to their 20 enumerated powers in that Article 1, Section 8. Remember how the founders gave them only 20 powers, and they're not to go outside of that, then they're going beyond their jurisdiction. So, this Equality Act that was passed last week by Congress that gives protection to sexual orientation from discrimination, protecting them from discrimination. Nowhere in the Constitution or in those 20 enumerated powers does it say they can do something like that. So once again, if it's not in the Constitution, per the Constitution, then it's meant to be resolved in the states, and the people in the states dictate, through their legislature and their governor, what kind of laws they want to live by in their state. And so these are little points of law that are being argued and will be argued in the coming days, as now that Equality Act is going to go to the Senate now. And I'm going to talk about that Equality Act in Amendment 1 in just a minute. So anyways, only limited powers are delegated to the government. And the Supremacy Clause tells you what is the supreme law of the land. And if the laws are not encapsulated within these three areas, then it's for the states and for the people to figure out, not for the federal government or for Congress to get involved. Once again, if the Constitution is silent, then it is up to the states to determine, even abortion. The founders never, intended the federal government to decide on gay marriage or abortion. It was supposed to be a state's right. But somehow, we have, and not somehow, next week I will tell you how, and really it's through Supreme Court decisions, and I'll show you how that they've overreached their boundaries, and instead of protecting the law, they've started to legislate from the bench. The Supreme Court has. Okay, so let's go to our very last article, which is Article 7. How do we ratify the Constitution? The founder said it would take, if we can get 9 states to vote for the Constitution, it will be adopted as the law of the land. And that's exactly what happened. A year after the Constitution was written, 11 states actually ratified it, and we were off to the races with the United States of America. Okay, so we're on our Bill of Rights, the Bill of Rights. Everyone turn to that page there. So the American Bill of Rights is really a legacy that came from tens of thousands of Englishmen who suffered torture and hanging and beheadings through the years, starting with the Magna Carta and then the Petition of Rights and the Writ of Habeas and the English Bill of Rights. So our founding fathers pulled some of those rights from those English documents through the years. And did you know there's actually a preamble for the Bill of Rights? Most people don't even know it exists. We know there's a preamble to the Constitution, but there's a preamble right before the Bill of Rights. You can read it. And what it is saying, it's a declaration, not necessarily of rights that we have, but it's more of a prohibition that they wanted to put on against the government, because they were so afraid. They had just come from England and this government that could come in and just do anything they wanted to. So they really wanted to restrict the federal government. And so it talks about, in order to prevent the misconstruction or abuse of its federal government powers, further declaratory and restrictive clauses have been added. And that is what they were referring to with these Bill of Rights. So it was really going to be further restrictions on the federal government, not a spelling out of more of our rights. So it was just going to prevent the government from further abuse of power, bind them down once again with the chains of the Constitution, the federal government. Okay, girls. Now, this next very First Amendment is juicy, and we're seeing a lot of action right now dealing with this First Amendment right. The first freedom that the government, that the founders intended, was the freedom to practice our religion, to have religious liberties. So there it says, Congress shall make no law respecting the establishment of a religion or prohibiting the free exercise thereof. So the framers were going to forbid Congress to make any laws respecting a state religion. Remember, they had the Church of England. Everyone had to subscribe to the Church of England back in that day. They did not want a federal one state religion. So this is why they put it that way. Thus, they wanted the states to be free to do, as several of them already had, to determine, rules of religion. And they were explicitly going to forbid Congress to abridge the free exercise of religion. All right. They wanted religion to be free to make its own way, but neither did they intend to have irreligion made into a favored state status. So our founders knew that without religion, a free people cannot be maintained, because religious people are looking to God, and they're studying the word of God, and they're studying the inalienable God-given rights. And the best way to ensure a republic is for people to remain morally strong and virtuous. And the way you do that is to elect morally strong and virtuous leaders. And that way they will always be rooted in the rule of law, or God's law. And it talks about, I just gave you principle 1, 2, 3, and 4. I just reeled them off. You might not have even known it. But that was the basis. The founders knew in order to keep this republic, we had to be a religious, God-fearing people looking to God in our inalienable rights, not government to tell us what our rights are, but to God. And then creating laws that will be in accordance to his law. And so I want to tell you something that has been misconstrued and distorted in the courts, and has probably gotten us to where we are as far as religions being squashed in this day and age. When Thomas Jefferson in 1802 was the president of the United States, now before that, he had served in the Virginia legislature, and he had put forth legislation to introduce a bill for a day of prayer and fasting. So if any of people like to say, well, Thomas Jefferson wasn't a religious man, he maybe didn't prescribe to a religion, but he was a deeply devout, spiritual man. And he wrote his own little Bible, Jefferson's Bible. Remember, we talked about that a few weeks ago. But when he was president of the United States, there was a group of Baptist ministers from Connecticut that came to him, and they wanted him, the federal government, to get involved in an argument that Connecticut was having about what should be their state religion. And Thomas Jefferson, the president, wrote back and he said, the Constitution has created a wall of separation between the state and the church. So I'm not going to get involved in this argument. And what he intended to mean was the federal government. When he said state and church, he meant the state of the union. There should be a wall between the state of the union and churches. So he intended that the federal government should not intermeddle in this religious matter in Connecticut, that it was up to the states to figure out how they wanted to handle religious treatment in their individual state. But guess what? From that letter that Thomas Jefferson wrote back to the Baptist ministers in Connecticut, that there should be a wall of separation between the state and religion and state, meaning the state, the federal state. 150 years later, the Supreme Court quoted Jefferson's metaphor, and they applied it to mean he meant the actual states, the 50 states, and the federal government should not pass laws that will be helpful to religion. So the Supreme Court in 1947 distorted this metaphor, and they used it as an excuse to tell not only the federal government, but the states that they couldn't intervene in anything religious. And that is completely contrary to what Thomas Jefferson meant. He knew that religions needed to be encouraged within the state to promote the moral fiber and the tone of the people, and that this wouldn't be possible if there was this impenetrable wall between actual states and the church. So Jefferson's wall was intended for the federal government not to institute like a Church of England, a national federal religion. It was not saying that the states couldn't get involved as well. So the Supreme Court from that time on, 1947, began to apply this metaphor not only to the federal government, but to the states. This is completely contrary to what the founding fathers intended. And so if you turn the page, I had to turn the page, it talks about how the Northwest Ordinance came along the same year the Constitution was signed. And in the Northwest Ordinance, it said that religion should be taught in all schools. Our founders put that. They intended religion to be taught. And Benjamin Franklin in the 5,000-year leap under that principle 4, where it talks about without religion, a free people cannot survive as a republic. He said there are 5 basic tenets of a universal or American religion. And he said all sound religions will have these 5 tenets. So he's not even saying Christian or non-Christian. He's just saying sound religions. So I think he's probably saying that means there's some unsound religions out there. This is what makes a sound religion, he said, that there is a creator. 2, that the creator has revealed a moral code, which defines right and wrong, that the creator holds mankind responsible for the way we treat each other. Number 4, that all mankind will live beyond this life. And number 5, that in the next life, individuals will be judged by their creator for their conduct. So Benjamin Franklin said these 5 tenets is what made up sound religion. And all of our founding fathers talked about this American, this universal religion with these 5 tenets. Samuel Adams said these basic beliefs constitute the religion of America. John Adams said these tenets are the general principles on which American civilization was founded. Thomas Jefferson said these basic beliefs are the principles upon which God has united us all. George Washington spoke of these religious principles as indispensable supports of good government. So the founders, look, there's a reason why, freedom of religion is the very first of the freedoms, because they knew that if we did not stay morally strong and grounded in our inalienable rights, we couldn't keep this republic. We would lean towards more of a democratic, what's the consensus and feelings of the majority of the people? That's how we'll make law. That's how we would lose the republic if we don't stay rooted in natural law, God's law, the principle of law. And so even remember Alex de Tocqueville that came over in the early 1800s. He was that French author, and he wrote that famous book, Democracy in America. And he wanted to know why this new little country was being so successful within a short amount of years. And even he in Democracy in America described this situation that he observed in the United States. Religion, he said, in America takes no direct part in the government of society, but it must be regarded as the first of their political institutions. I am certain that they hold it to be indispensable to the maintenance of their republic. Okay, so this is how our founders felt. But because our Supreme Court misinterpreted that wall of separation writing of Thomas Jefferson, look what came forth from that in the early 1900s. In 1925, the Supreme Court issued an opinion saying that the Federal Bill of Rights not only applied to the government, but to the states. And then in 1948, McCollum versus Board of Education, they prohibited the teaching of religion in school. In 1947, Everson versus Board of Education, the Supreme Court said the federal or the state could not encourage religion in any way. And then in 1962, Engel versus Vitale, they outlawed prayers in school. And then the Supreme Court in 1963 outlawed saying the Lord's Prayer or Bible reading verses as unconstitutional. I'm sure Thomas Jefferson is rolling over in his grave because of how the Supreme Court distorted and misinterpreted what he had said to those Baptist ministers in 1802. And this is some of the problem that we have today as religious liberties are being squashed, where we can't have a Bible club at school and high school anymore, but we can have an LGBTQ club. And this is completely contrary to what our founders had intended. So look here, the second provision of the First Amendment says that Congress shall make no law abridging the freedom of speech. And we are seeing this battle played out right before our eyes for this First Amendment rights of freedom of speech in this cancel culture that we are seeing. So we think of big tech right now. I don't know if you've heard of the Section 230. They're trying to pass some laws to repeal or rein in legislation that was passed in 1996 called the Communication Decency Act. And really, that legislation in Congress was passed back then in 1996 as a way to protect children from looking at pornography. But what has spawned from that 1996 legislation is that big tech, Facebook, YouTube, Twitter, can now come in and censor and silence things that they consider unsafe or violent. So really what we're seeing is if you have dissenting opinions about maybe the election or COVID, you can be taken down by big tech. And that is an infringement for sure on freedom of speech. And this is why you're seeing so much litigation right now because of some of the things, legislation that has come forth and it being taken to court now. And I just saw Giuliani's YouTube channel was suspended because, obviously they don't, big tech doesn't like his views. And even Moms for America, our little Facebook page from time to time is being threatened of being pulled down for controversial issues. Can you imagine that? Talk about a limitation of free speech. So it's interesting, just last week, I don't know if you saw or heard this, but a district court in Oregon made an interesting, put forth an interesting opinion about this freedom of speech, First Amendment right. Now remember, the federal government, we have district courts, we have 94 district courts, then we have 13 appellate courts. You can appeal to the appellate court, or then the Supreme Court. And most of the cases that have to do with a federal question stop at the district court. The appellate courts won't hear them. And certainly, 10,000 cases come to the Supreme Court. They only hear 95 of them each year. So most cases that make it to the district court stop there. So the district court last week in Oregon, a judge by the name of Mossman, he was appointed by Bush 43. So he's probably a conservative judge out of Oregon. He declared that the Miss USA pageant is allowed to only accept natural born women, and they cannot be forced to accept transgender men in their pageants. And the judge went on to say, and he based it on this First Amendment, this freedom of speech, because it's an organization, he said, the judge, that promotes a message and seeks to maintain control. They want to maintain control of that message, and they shouldn't be required to have to alter that message. And then he referred back to a Supreme Court a few years ago where they said New Jersey couldn't be forced by the Boy Scouts to accept gay scoutmasters. So he used that as precedence. And the plaintiff said, look, in a society where women receive fewer opportunities than men, women deserve a platform to be able to compete and to speak and to be celebrated. And so he ruled in favor of the Miss USA and said transgender men are not allowed. Now this goes contrary to the Equality Act that was just passed in the House, protecting transgenders and saying that they can compete in women's sports. And it's particularly going to infringe upon women's rights, this Equality Act, and upon children's rights, because now boys will be in the girls' locker room, and upon religions that might, now have to be obligated to marry transgender people. So can you see there's a conflict happening here? So the district court ruling conflicts this Equality Act. Now the Equality Act has passed in the House, but not in the Senate. Now they have enough votes. They have the majority in the Senate, but there is a filibuster rule in the Senate. They don't have the filibuster rule in the House. There's a filibuster rule in the Senate that says you can keep talking legislation to death on the floor until it eventually dies, unless you have 60 senators that will vote to stop the filibuster and to vote on it. So at this point, I don't believe they have 60 votes that would stop, like Rand Paul would probably, a filibuster. You talk all night, you can talk for days on end, different senators will spell each other off. And eventually it just dies. So right now there are not 60 senators that will stop the filibuster. So the Senate doesn't necessarily have the votes to pass the Equality Act. So that bill could die, which would be probably a very good thing. And so we're seeing this First Amendment, freedom of speech being played out right before our eyes every day in the newspaper. And so when you understand what our founding fathers intended, that if the Constitution is silent on certain issues like transgenderism, that should go back to the states to decide. And we will clearly see that in Amendments 9 and 10 that we're going to study in just a minute. So that's a lot to think about right there, but we have 9 more amendments, but we'll go quickly through the 9 amendments. So the Second Amendment is the right to be able to bear arms. Ladies, our founders knew that in order for free people to survive, they must have a strong military and they must stay strong themselves. They felt this was an inalienable right to be able to protect your life, your liberty, your property. They've said in a nation where leaders want to suppress the people, they start by asking them to register their firearms. And then sometimes they will deliberately provoke rioting or violence as an excuse to confiscate these arms in the possession of private citizens. Have we seen that every time there's a mass shooting or a shooting spree? There's cries to restrict our gun control. But really, if you look at statistic and crime reports, gun control does not curb crime. Look, criminals are going to find a way to get a gun, whether it's legal or not. And did you know one of the first things Hitler did when he came into power was to take everyone's guns away from them? Isn't that interesting, to disarm civilizations? And even the Soviets, Khrushchev, when he was the president of the Soviet Union in the height of the Cold War, he was very reluctant to come against us because the US citizens are known to be well armed, and it is a deterrent. So this idea, like you can't take your guns with you when you go into the movie theater, is that somehow supposed to make you feel safer? Because all a criminal needs to know is this is a place I can go in and have a heyday because no one is armed, versus being able to take your arms with you everywhere you go. A criminal would think twice about going into a movie theater, knowing that if he started a spree, there was probably 5 people with guns that would take him out immediately. And so we're more likely to be safer if we have an armed citizenry. And so our founders knew that this was a God-given right to be able to protect ourselves, our families, our properties. Okay, the Third Amendment basically just said troops can't come in and hang out in your house. This was a problem during the Revolutionary War, not so much a problem in this day and age. The Fourth Amendment talks about the rights no rights to unlawfully and unreasonably come in and search and seize things in your home without probable cause. You must have a warrant. Now, this was all going on in the early history of America, and this is why our founders were sensitive to these things. And then our Fifth, Sixth, Seventh, Eighth Amendment all talk about the rights of the accused, that they have certain rights, that they don't have to testify against themselves, and they have due process of law. They have to go through proper procedures of having an indictment and a trial, and they can have lawyers, and they have to be found guilty. And because remember, all throughout history, mostly the law could come in, grab you, a judge could say you were guilty, throw you in the dungeon, and you're in jail the rest of your life. I just watched The Count of Monte Cristo, and I think about what happened to him as a young man. And so our founders were very sensitive to protecting the rights of the accusers. And so that's what the Fifth, Sixth, Seventh, and Eighth Amendment had to do with that. So we get to the Ninth and 10th Amendment, and it just underscores what I've been trying to teach you, that the Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage the others retained by the people. So what they're saying here is people have more rights than what is listed in the Constitution. And just because certain rights aren't listed in the Constitution doesn't mean that we therefore don't have these rights, that the citizens can claim all their rights that belong to them. So it was kind of a catch-all phrase to protect all their other rights that might not be specifically enumerated or listed in the Constitution. And the 10th Amendment, once again, places power in the states and the people. The powers not delegated to the United States by the Constitution nor prohibited to it by the states are reserved for the states respectively, or to the people to figure out. The amendments were designed to fix the chains of the Constitution on the agencies and elected officials of the federal government. All right. And so that is, unless the Constitution specifically spelled out assigned duties to the federal government, it had no authority to enter into that field of endeavor. That's why that Equality Act is wrong, because what it's going to do, it's going to infringe upon the rights of the religious rights of people. They're going to take away religious rights. It's going to infringe upon the rights of women and the rights of children. So, you know, when the courts start to get involved, or legislators start to legislate beyond their 20 enumerated powers, it starts to infringe upon our inalienable God-given rights. So we're starting to see the baker has to bake the cake with two men on top of it. Or if you're going to rent, your basement out, you have to rent, even if you have children, to a transgender couple. Or if your child has a transgender teacher, you have no recourse. That's, some of what has transpired since gay marriage was legalized. And now we're starting to see, Equality Act legislation that looks like we have a president that would support it, and we have a House that would support it, and even a Senate support it. The only thing stopping us from it being passed right now is that filibuster 60 senator rule to stop the filibuster in the Senate. And so that's what you're getting, is an infringement on religious liberties. People that adhere to certain convictions and inalienable laws by God are not going to be able to exercise those religious rights because of some of this legislation that is coming forth from Congress and some of these Supreme Court cases that have weakened our religious liberties. And so once again, and it tells us, Principle 19, only limited and carefully defined powers should be delegated to the government. All others shall be retained by the people and the states respectively. So there you have it, my dear sisters. Woo, I always feel like we just have to let out a little sigh when we can get through our material, because seriously, you are learning the Constitution, something that would take years and years for law students to figure out. We're doing it at lightning speed. And so can I just ask you to do one thing, to go back and review our lesson today. They say if you will review something within 48 hours from the time that you learn it, your retention of it will be increased by 50%. So go back, please, and read this section one more time today. And I also would like to recommend, once again, get this little catechism and go through a page or two with your children, or just you and your husband before you go to bed or over breakfast or something. And it's the Socratic method. It asks you questions about the Constitution. So that's one way you can kind of learn the Constitution. Girls, I have used this book for years with my children. It's called Enabling the People, the Amendments to the Constitution. And it's a fun way to teach your children the amendments in a really simple way. It explains what, like Amendment 8 here is, really simply. And then, so it takes you through the 27 amendments. I tried to get it on Amazon and it said it wasn't available, but I believe if you go to the website, and I think Vivian put this on the email you received yesterday, if you go to the website, I'm hoping you can still get this book. I would highly recommend this book for teaching your children or grandchildren about the 27 amendments. And then, of course, we have just that one-page outline, which is so helpful. Just like make 10 copies and just tuck them away in your books, okay? If you can kind of memorize just this little page, you will know more about the Constitution than even politicians. Because we've asked politicians before, what do you think about the 8th article? And they start talking about the 8th article, and there's only 7 articles. So that's a dead giveaway that, you know, they're not learned in the Constitution. Also, I recommend, if you don't have it yet, get that 3rd manual, because next week is our last lesson out of the Charter of Constitution, the Charter of Freedom. And then we're going to start our 3rd seminar, the attacks of the Charter of Freedom, the attacks on the Constitution, what has happened. And this is such a fascinating seminar. And also the Making of America book. Sorry, I'm just overloading you with resources, but you're going to need some additional resources we can't just say after our one little seminar, okay, I think I understand the Constitution. You're going to need some other little resources. I really like this Making of America book. You can get it from the kimbercurriculum.com. And I'm not sure how much it is, but it explains every single line from the Constitution, what our founding fathers meant. And of course, the 5,000-year leap. And girls, I think I'm going to teach a 5,000-year leap book this fall class on the 5,000-year leap. I memorized these 28 principles. This is how powerful I think this book is in understanding the Constitution and defending yourself from a bunch of emotional arguments that you hear nowadays. So those are some resources. And also there's a video called The Tale of Two Constitutions. And it's, if you just Google Tale of Two Constitutions, it comes up. It's a 2-part. Part 1 is 8 minutes. Part 2 is 9 minutes on YouTube. And it helps to explain what we're going to study next week, the amendments 13 through 27, and how some of them have superseded and changed what our founders intended. Because every time you pass an amendment, it changes a little bit about what the founders gave us. It supersedes some existing law that our founders gave us, and that's not a good thing. I'm just here to tell you that. So, Tale of Two Constitutions. One is an 8-minute video, one's a 9-minute video, and it will just kind of help you to understand some of these amendments that we're going to study next week. So girls, that is it. I hope you're not feeling overwhelmed. The wonderful thing is knowledge really is power. And when you begin to understand what our founders intended, you're like, wait a minute, we begin to understand what the solutions are. We don't just spin our heads and go, I don't know what to do. This is not right. This doesn't feel right. We begin to explain to them what Thomas Jefferson meant about a wall of separation between the state and government and religion and the state. And so then the Lord begins to infuse within you a little confidence, and a little knowledge makes you more confident, and it makes you more hopeful. Someone said to me on Sunday at church, Julene, what is something the government could do to help protect our rights? And I said, look, that's the whole problem. We don't turn to government to tell us what our rights are. We turn to God. And I told him, we turn to God. And then we teach these things to our family. We make family time a high priority. And then we study the Constitution from the viewpoint of the founders. And then God will let you know what to do. Should you join a group of like-minded people? Should you start a group? Should you run for office? Should you support someone in office? And that's how you stay anchored in hope. And I hope, girls, that you are feeling anchored in hope, that you're frustrated sometimes by some of what you see, but you know the solution to it. And when you know how it got broke, you know how to fix something. And so anyways, that is the end of our class today. Thank you for enduring to the end.